Hello everyone, I am Professor Werner Null. In this learning unit, we will explore what is commonly called constitutional criminal procedure. We will examine how the Constitution has shaped the criminal justice system in South Africa, the human rights and due process safeguards that protect arrested, detained and accused persons, and how these rights shape and limit the exercise of state power, specifically law enforcement powers in South Africa. This discussion index provides you with a basic framework of the main topics that we will discuss in this learning unit.
Let's now consider the effect of the Constitution on the criminal justice system. Now, very importantly, as a starting point, the principles applicable to the criminal justice system, whether that would be substantive or adjective criminal justice, do not, may not, and cannot operate in isolation from the Constitution. The Constitution is the highest authority, the highest law in South Africa, and there are principles that are either directly or indirectly applicable to the criminal justice system.
Guided by the rights and values of the Bill of Rights, particularly dignity, freedom, and equality, the Constitution of South Africa has profoundly shaped the meaning of criminal justice within our constitutional democracy. It has reorientated the criminal justice system away from the apartheid era's rigid enforcement of crime control model, which we said is effectively a police state model, and it has reorientated that criminal justice system towards a predominantly due process or procedural fairness model with a more limited emphasis on crime control, in other words, crime prevention. Now, this due process model is, at least in part, realized through a range of constitutionally entrenched rights. When I refer to constitutional rights, it includes human rights, the rights that we find in Chapter 2 of the Constitution, and also includes the specific procedural rights, the due process rights, that is not available to everyone, but which is afforded specifically to arrested, detained, and accused persons. Together with the constitutionally entrenched rights and normative values we've discussed, the due process model operates through a system of checks and balances. Now, these checks and balances ensure not only that substantive and procedural criminal law, in other words, that extends to common law principles and legislation, aligns with the Constitution, but more importantly for our purposes, these checks and balances ensure that the state's exercise of crime-fighting powers, which inherently affect constitutional rights of those coming into contact with the criminal justice system, that these exercises of power remain within reasonable and constitutionally justifiable limits. So for that reason, we can say that the constitutional due process model shapes how participants in the criminal justice system exercise power and interact with anyone coming into contact with the criminal justice system. So by effect, it promotes the achievement of crime control objectives, but through the reasonable and proportional exercise of crime-fighting powers, thereby balancing the interest of society in crime control with those of the individual. Now, in doing so, it safeguards the affected individual against dehumanizing or degrading treatment, while also ensuring that the inevitable consequential effect on the person's constitutional rights are mitigated. So in short, we can say that the whole idea with our criminal justice system, our due process model, is that both the substantive and procedural law, together with the exercise of state power in relation to the criminal justice system, must be consistent with the Constitution and the rule of law.
The Constitution has had a profound impact on our legal system, least of all the criminal justice system. And I would refer you to your other prescribed sources to have a look at some of the important effects of the Constitution. What we are going to do in the next few slides is focus our attention on the most important effects of the Constitution on the criminal justice system. So first, The testing right. We already said on the previous slide that the Constitution is the highest law in South Africa, and any law or any conduct inconsistent with it can be declared unconstitutional. And this is done by way of the superior courts, the higher courts in South Africa. And when read with Section 172 of the Constitution, higher courts can basically assess whether a law or conduct is inconsistent with the Constitution, and if so, make a certain declaration or provide certain remedies. Now, this idea extends to both substantive and or procedural criminal law. So in other words, the law as it relates to criminal justice. So whether the law pertains to criminal law aspects, law of evidence aspect, or criminal procedural aspects, all of that is considered law and can be tested and should be tested against the Constitution. And so we've had it that there are sections from the Criminal Procedure Act that has been declared unconstitutional, for example. But as we've said, it's not only about the law that must be consistent with the Constitution, it's also conduct. And for our purposes in the criminal justice system, here we are talking about the conduct of those exercising state authority. For the most part, we will spend our time looking at the exercise of crime-fighting powers by the SAPS, and to a lesser extent, the exercise of the discretion by the prosecuting authority to institute prosecution or not. And the exercise of their power, the conduct that emanates from the law in terms of which they exercise this power, that conduct and that law must be consistent with the Constitution. So any conduct by a law enforcement agency, functionary, SAPS officer, or correctional services supervision, or prosecuting authority agent must comply with the constitutional values and the rule of law. And the exercise of these investigatory powers, for example, that are inconsistent with the Constitution will be declared invalid and unconstitutional. And the moment that happens, let's say, for example, a police official conducted an unlawful search and seizure, then there will be certain remedies available to that the person, usually the accused that has been impacted. There will be remedies available to that person as a result of that unlawful search and seizure. So what the effect of this testing right is on the criminal justice system is not only that the law must be consistent with the Constitution, it also places certain limits on the exercise of state power and the way crime-fighting authorities conduct themselves, the SAPS conduct themselves in the exercise of the investigatory powers. So it limits what they can do and the extent of what they can do. The second important effect of the Constitution on criminal justice we find in the constitutional values themselves. And we've already said that the values are dignity, freedom, and equality. And these have positively impacted the spirit of the criminal justice system. How people think about the criminal justice system, how people think or should think about an alleged perpetrator and interact. And when I say people, I'm often referring not only just to law enforcement agencies or functionaries, I'm referring to society as a whole. So criminal justice related laws and conduct, as we said, of those exercising state authority within the criminal justice system must be guided by a fundamental respect for the dignity, freedom, and equality of everyone. Because that person is entitled to human dignity beyond just pre-trial and fair trial rights, just because this person is a human being makes him or her entitled to a certain level or standard of treatment. Then, equality and non-discrimination. This is a big deal in South Africa, and we find this in the Equality Clause in Section 9. Now, the Equality Clause in Section 9 doesn't say anything about the criminal justice system per se, but we can read these values, these rights, into the treatment that people experience in the criminal justice system. So effectively, Section 9 says that everyone is equal before the law and has the right to equal protection and benefit of the law. So the Equality Clause prohibits unfair discrimination, and that extends into the treatment in the criminal justice system. So when exercising state authority in the criminal justice arena, individuals that come into contact with these exercises of state authority are safeguarded against overzealous or discriminatory practices. And that is where Section 9 plays a very important role, that all people are treated the same by law and by those exercising law enforcement powers in the criminal justice system. So this must be done equally and fairly. Then we can look at the principles of access to justice. Effectively, what Section 34 of the Constitution says that is that whenever there is a dispute between two parties, that dispute can and should be resolved by way of access to justice before a fair, public hearing, independent and impartial court. And when we're talking about the criminal justice context, it means that if the state is making an allegation against me that I am disputing, then I must be brought before an ordinary court, and I have the access to justice that is outlined in Section 34 and elsewhere in the Constitution. So in relation to the criminal justice system, no person should be detained or should be punished without being brought to answer by way of due process of law before an open court. Punishment or detention cannot be handed out without there being a basis for this, and the basis must be decided by access to justice by an ordinary impartial court. Fifth, we look at what the effect of the entitlement to human rights have had on the criminal justice system. So we've already mentioned the fact that everyone is constitutionally entitled to certain human rights, everyone. So on the one hand, that means for a victim who is entitled to these rights, when they become the victim of an offense, we said earlier that infringes on their human rights, which they have the right to protection of. And for this reason, because crime has an effect on human rights, we need crime control measures, because crime control measures play an important role in protecting society against the infringement on interests and human rights. Now, on the other hand, we've already mentioned as well that the perpetrator is also constitutionally entitled to the same fundamental human rights. And we say to each other, we need to think about justice from the perspective of the perpetrator as well, because the perpetrator is innocent until proven guilty. And any person, including you and I, may potentially be a suspect and as a result come into direct contact with the exercise of investigatory powers by the SAPS. And the exercise of those powers will negatively impact on my human rights. And so for that reason, we do need certain protections against the exercise of state power to protect our human rights. So, to protect society against the abuse of law enforcement powers, every exercise of state power that infringe on human rights must be reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. So effectively what we are saying is, if I find myself to be the perpetrator in a specific case, I have the right to the same constitutional protections and a few others as we've mentioned, because in the exercise of investigatory powers, if I find myself in this context, my rights will be infringed. And for that reason, whenever these exercises of authority infringe on rights, Such infringements must be reasonable and justifiable. Let's use an example. The exercise of arrest as an investigatory power is very important for police. It is necessary because they want to bring the suspect to the police station to question him or her, to take fingerprints, etc., etc. So, exercising the power of arrest plays a very important crime control function. However, at the same time that it is important and necessary, it also has severe effect on fundamental human rights. Arrest has a big impact on a person's freedom of movement, their bodily integrity, their privacy, and so forth. And so effectively what we are saying is, because the exercise of these powers impact on human rights, they must be done within certain limits. Limits such as reasonableness and justifiability in a society that is based on the kind of constitutional values that we spoke about earlier, so that we limit the extent of state power and therefore limit the extent of the infringement on rights to only instances where it is really necessary for those investigatory powers to be exercised and the consequent infringement on rights that go hand in hand with the exercise of that authority. Staying with the entitlement to constitutional rights, an accused, an arrested, or detained person is also entitled to constitutional due process rights or procedural fairness rights that we find in section 35(1), 2, and 3. Now, unlike human rights to which everyone is entitled, these due process rights are only applicable to arrested, detained, and or accused persons. We've already mentioned that these rights safeguard procedural fairness, to be treated fairly in the administration of justice throughout the criminal justice system. And importantly, while the exercise of state authority in relation to crime control is necessary, it must be achieved within certain limits. And those limits include the limits that do not unfairly and unjustifiably infringe on the human rights, but also on the procedural fairness rights of arrested, detained, and or accused persons. Now, what we discussed on the previous slides is that a person is entitled to a number of constitutional rights, including human rights and due process rights if he or she is arrested, detained, and or accused. But it is important to know that none of these rights, as important as they are absolute. And the implication is, therefore, that there is likely to be infringements or limitations on these rights, and under certain circumstances, such limitations or infringements are justified. And that is where Section 36 of the Constitution plays a very important role. All constitutional rights may be limited, and that is not only applicable to criminal justice processes only, but for our purposes, all constitutional rights, which includes human rights and due process rights, may be limited during the criminal procedure processes and the exercise of crime-fighting powers that go with that. But such infringements that occur as a result of the exercise of crime-fighting powers must be reasonable and justifiable in the interests of justice. So we spoke about the reasonable checks and balances earlier, and that is what Section 36 discusses, that the limitation on a person's rights is justified in the exercise of crime-fighting powers, but only if it is justified under the circumstances. And so here, things like the reasonableness test plays an important role. Aspects such as the necessity of action, the extent of the exercise of authority, all of these things play an important role to decide whether or not the infringement that resulted from the exercise of crime-fighting powers is constitutionally justifiable. So often during the investigation stage, during detention and even during sentencing, that these infringements on rights occur, as we said on the previous slide. Arrest is necessary, but arrest has certain consequences on human rights. And Section 36 describes this process of the court, which the court must undergo and go through to decide whether or not, under those circumstances, the infringement on rights was reasonable and justifiable in the interest of justice. So the effect of Section 36 is that it encourages reasonable and fair crime control measures. It places these limitations and checks and balances on how the state exercises authority. And it makes a police official, or should make a police official, think twice before he or she exercises crime-fighting powers that infringes on a person's human rights or due process rights. Finally, and very closely related to this question regarding the justifiability of the exercise of state power, is Section 35(5) of the Constitution, known as the exclusionary rule. So when we looked at Section 36 of the Constitution earlier, we said that Section 36 allows for the infringement on rights or the limitation of rights by way of the exercise of state power under certain circumstances. Now, the court is given a testing right, and in that exercise, if the court comes to the conclusion that the exercise of state power under certain circumstances or in a certain context was not justifiable, it could have an effect on the admissibility of the evidence at trial. So we spoke about the fact that during the investigation of a crime, the law of evidence, and specifically in criminal justice, the Criminal Procedure Act, allows for a number of investigatory functions to be exercised by the SAPS. Things like search and seizure and those sorts of things are allowed for. But the exclusionary rule says, essentially, if in the interest of gathering evidence is obtained in a manner that violates any right in the Bill of Rights, that evidence potentially may be excluded or must be excluded if the admission of that evidence would render the trial unfair or would otherwise be detrimental to the administration of justice. So this is another way in which there are limits placed on the extent of law enforcement powers. The law enforcement powers are necessary, it's important for crime control, but there must be limits on the extent of exercising such powers, because otherwise exercising such powers would become overzealous and unjustifiably infringing on human rights. And so if in a search, in a seizure, during a certain criminal investigation, things are done by police officials in a wrongful manner, and they obtain such evidence may be excluded at trial by way of Section 35(5). So it essentially provides a constitutionally enshrined procedural remedy against the unreasonable abusive exercise of investigatory powers of police, and therefore it discourages police to gather evidence in an unlawful way, because that evidence would then not be used or be capable of being used during trial.
Something like due process is definitely not something that is new to our legal system. If you think about the principles of audi alteram partem, nemo judex in sua causa, those are principles that come from common law, and they are hundreds of years old. But what we do have in South Africa are the due process principles as we know them, enshrined in the Constitution of South Africa. And then in the context of criminal procedure, we have Section 35 that provides or guarantees specific fundamental criminal procedural rights to arrested, detained, and accused persons. And these include things like the right to silence and the protection against self-incrimination, which has always been part of due process principles, the right to counsel and legal aid, which is very much broadened in the South African context, the right to a fair trial, the presumption of innocence, and the prohibition of double jeopardy and ex post facto crimes. Now, the important thing here is that the expectation is that you must understand and study Section 35 of the Constitution. It's a long section. I'm not going to ask you to rewrite the section for me verbatim, but you will have to be able to answer a 10 or 20 question, 10 or 20 mark question regarding the rights enshrined in Section 35. And here, it becomes extremely important that you understand the roles that we discussed a little bit earlier. In Section 35, it differentiates between arrested, detained, and accused people and gives them specific rights based on which category they belong to. And as we said earlier, there is an intersection between these roles, but there are instances where a person is one and not the other. And so under those circumstances, it's important that you are able to identify which rights accrue to this specific person. And then the roles that we discussed under the previous part becomes very important. As we've already mentioned, South Africa's criminal justice system is primarily based on a due process or a procedural fairness model. And the idea with this model, specifically in terms of Section 35 of the Constitution, is safeguarding individual rights and interests by limiting the powers of law enforcement agencies. And we say to each other, the whole idea in this regard is that criminal justice, the concept of justice in criminal law, is not one-dimensional. While we want to pursue justice for the victim and on behalf of the interest of society, we should also do that without causing or resulting in further injustices by not following processes and procedures in the process of holding someone accountable and potentially then making the mistake of holding someone responsible who has not committed an offense, or holding someone responsible who committed an offense but the punishment attached does not fit the crime. All of these things refer to being treated justly in the criminal justice system as a perpetrator, or from the perspective of the perpetrator. So the idea is balancing the public demand for effective protection against crime with the constitutional rights of those being investigated, arrested, accused, convicted, etc. So what we have is a system where positive crime control powers are granted to law enforcement powers or agencies such as the South African Police Service in South Africa, but that there are certain limitations, parameters within which they may exercise these powers. And this is provided by various checks and balances in the Constitution, in the common law, and institute, like, for example, the Criminal Procedure Act. And the idea with limiting the exercise of these powers is to ensure that the exercise of these powers serve the objective of crime control without being abusive or overzealous. As we mentioned, the due process model in South Africa comprises both substantive and procedural constitutional rights that is guaranteed in Chapter 2 of the Bill of Rights, and these intend at protecting the fairness and justice owed to arrested, detained, and accused persons throughout the criminal justice proceedings. Now, this is achieved through various constitutional rights aimed at substantive and procedural fairness, including general human rights, which we are all entitled to, including an alleged perpetrator. So these are rights like the right to privacy and property, dignity, freedom of expression, and so forth. But in particular, because we have the due process model, Section 35 of the Constitution provides for certain due process or procedural fairness rights, and these rights are only applicable to arrested, accused, and or detained persons. Now, these due process rights may be subdivided into two categories: the pretrial rights in section 35(1) and 2, and the fair trial rights in section 35(3). These due process rights in sections 35(1) and 2 primarily protect arrested and or detained persons during arrest, incarceration, and during the pretrial investigation phase in particular, not exclusively. On the other hand, the fair trial rights in section 35(3), which is applicable to accused persons, effectively extend throughout certain pretrial court processes, but obviously then throughout the criminal trial, sentencing, and the post-trial remedies such as appeal and review.
Although it may, under certain circumstances, be acceptable to refer to someone as an alleged perpetrator or suspect, there are specific, technically legal descriptors or designations that should be used to refer to a perpetrator under certain circumstances or within certain contexts. So it is sometimes okay to refer to someone as a perpetrator, but you must be able to refer to that person by their appropriate legal designation when the circumstances call therefor. So I also remind you of the fact that these descriptors may exist in isolation. So for example, a person who has been accused but has been released on warning to appear at his trial date and can go about his life without staying in prison is only the accused, is no longer an arrested or detained person. But you should also keep in mind that multiple descriptors or designations may exist at the same time. So, for example, a person may be arrested, and the moment they are arrested, they also fall within the ambit of a detained. So both arrested and detained at the same time, and for that reason they are entitled to both section 35(1) and section 35(2) rights. It may even happen that a person is arrested and is therefore detained and is kept in custody in anticipation of trial because they have been charged with an offense, which means they are entitled to the rights in section 35(1), 2, and 3. I also want to remind you of the fact that these descriptors are not fixed. A descriptor might be applicable at one stage, but that is changeable. I may be arrested and detained on one day, but I may be released from custody and those descriptors no longer apply. At that stage, I might only be an accused, or I may have been released and none of the descriptors apply at all. So these descriptors exist simultaneously, potentially simultaneously, and they are changeable. And keep in mind that each of these descriptors, whether they exist in isolation or together with another or more than one other descriptors, they link directly to the rights outlined in section 35(1), 2, and 3, and a person's status dictates which of these rights they are entitled to at a specific time. Let's look a little bit more closely at the rights of an arrested person in terms of section 35(1) of the Constitution. Everyone is arrested for the purposes of allegedly committing offense. So there are other reasons for arrest as well. The rights attach here to an arrested person who is arrested for allegedly committing offense, and this person has a number of important rights. First, the right to remain silent. Now you must keep in mind that most, if not all, constitutional rights includes both the positive and the negative polar opposites of a certain right or freedom. So what I mean here is the right to remain silent always includes the opposite as well, the right not to remain silent. So while I have the freedom, I have the right to remain silent, I also have the right not to remain silent and say something. And keep this in the back of your mind as we go through all of these rights. With some of them, it is less important than for others. Right, at the starting point, back to the rights. The arrested person has the right to remain silent, and very closely related to that, the right to be informed promptly of this right to remain silent, but to also be informed of the consequences if he or she chooses not to remain silent. In other words, if he or she does not remain silent, that information can be used against that person in court later. Then, a person cannot be compelled to make a confession or admission that could be used in evidence against that person. This is, again, very closely related to the right to remain silent. Because the person has the right to remain silent, they cannot be compelled to make a statement or a confession. And they have the right to remain silent, and they have the right to be informed of this and this possibility that if they do not remain silent and they do exercise the right to say something, that can be used as a confession or admission against them as part of the evidence against that person later. Then, this person, once he or she has been arrested, cannot stay in captivity or in detention indefinitely. They must be brought before court as soon as reasonably possible. Now, in many instances, if a person is arrested, especially for lesser types of offenses, let's say drunken driving or assault at a bar or something like that, they probably won't be brought before court. There will be different ways in which release may be secured. But if release is not secured in any of the other ways, I'm talking about prosecutorial bail or police bail, that person must be brought before court within a reasonable time, but not later. In other words, there's an outer maximum limit of 48 hours after the arrest. Or, if that person cannot be brought to court within 48 hours, there are certain exceptions to this 48-hour rule. So the 48 hours after arrest before court excludes certain days which are generally not considered court days or court hours. So the moment 48 hours falls over the course of a weekend or in a public holiday, those are excluded. And if that is the case, the person must be brought before court at the end of the first court day after the expiry of the 48 hours. And that means that the person is still brought before court within a reasonable amount of time. Does imply that, for example, over a weekend or over a long weekend especially, a person is potentially going to spend more time in custody than just 48 hours. Then, very importantly, the person has the right to a first appearance after being arrested. Now, first appearance after arrest is not a formal, it's not formal terminology that I'm using here. First appearance after arrest is basically this instance where the person is brought before court as soon as reasonably possible, and a number of important things must happen at this stage. When this person is being brought before court for their first appearance as a result of the arrest, they must either be charged as a result, or they must be informed of the reason if the court decides that the detention should continue, or they must then be released. And very closely related to this is that there is this presumption of release from detention if it is in the interest of justice. So release from detention is almost the default position, so to speak. Why is that? Well, first, this person is supposed to be innocent until proven guilty. And secondly, this situation that the person finds him or herself in, being arrested, is a serious infringement on a person's constitutional rights. And for that reason, there must be good reasons for this detention to continue. So for that reason, there is kind of this default that the person should be released from detention if it is in the interest of justice, and this is generally subject to certain reasonable conditions. And this refers to bail and bail conditions attached to a release from detention. So these are the rights that an arrested person is entitled to in terms of Section 35(1). Remember, an arrested person is per definition also a detained person, and will therefore also be entitled to the rights in Section 35(2), which we will look at in a few slides. Let's carefully look at the rights of the detained person in terms of Section 35(2) of the Constitution. Now, the subsection starts by saying, everyone who is detained, including, and I can include there in brackets, including but not limited to, a sentenced prisoner, has the following rights. Now, why do I say that? Remember, per definition, an arrested person is always also a detained person, and an arrested person will have the rights not only in Section 35(1), but also Section 35(2) available. What you will see as we go through these rights is that some of these rights make sense, practical sense for an arrested person, but might not make practical sense for other types of detained persons, such as sentenced prisoners, any longer. So let me illustrate with reference to the first right here. The first right is the right to be informed promptly of the reason for being detained. Now, the moment a person is arrested, this is an important right, to be informed, but why have I been arrested? But when it comes to a sentenced prisoner who knows exactly why they are being detained, they've been found guilty of the offense and they are now serving their imprisonment sentence, this right no longer makes practical sense. And you'll see as we go through the list, there are other rights in this category that make sense for an arrested person, but not necessarily for a sentenced prisoner. Moving on, the second important right is that of legal assistance, a legal practitioner, to be informed of the right to a legal practitioner. Now, two options exist here. Either I choose and I pay for my own legal practitioner, or for indigent persons that cannot afford their own legal practitioner, and if substantial injustice would otherwise result, a legal practitioner may be assigned, in other words, no choice, may be assigned to this person by the state and at state expense. Right. So here, the Legal Aid Board in South Africa and the Legal Aid Act play a very important role to assist impoverished persons who cannot afford their own legal practitioners to have a fair trial by appointing a state practitioner at state expense. Then, a detained person has the right to challenge the lawfulness of detention in person before a court, and if the detention is unlawful, to be released. Again, for an arrested person, this is very important, but for a sentenced prisoner, this no longer makes a lot of sense. Then, to minimum conditions, the type of conditions that a person is held in, whether a sentenced prisoner or arrested person, must comply with certain minimum requirements. Having said that, I can interrupt myself very quickly to say that generally, arrested persons and sentenced prisoners are kept separately. Nonetheless, there are certain conditions of detention that must exist that is conducive to human dignity. And so these include at least exercise and the provision at state expense of food, accommodation, reading material, medical treatment, and so forth. Also, part of the conditions of detention, to be visited by and to be able to communicate with specific persons, such as a spouse or a partner, children, a religious counselor, a chosen medical practitioner, especially in the case of specialized medical care. Let's have a closer look at the fair trial rights of an accused person in terms of Section 35(3) of the Constitution. So the section starts by saying every accused person has a right to a fair trial, which includes a number of rights. In other words, the essence of Section 35(3) is to ensure that the person is given a fair trial, fair and reasonable administration of justice. So to ensure that this person, during the course of the criminal trial, is treated fairly, he or she is entitled to a number of important rights, including the right to be informed of the charge with sufficient detail to answer it. If they are expecting me as an accused person to answer to the charges by pleading to the charges, then I must know what is the basis for the charge and which crime they are charging me with. Now, this is an important implication for the drafting of a charge or charge sheet. Then, the right to have adequate time and facilities to prepare a defense. And this is particularly important in the case of persons that have been arrested and are being detained in anticipation of trial. Then, the right to a public trial before an ordinary court. Now, an ordinary court in this regard is simply the kind of court that is referred to in Section 34 of the Constitution. So it's an independent and impartial court that is open to the public. So justice must be seen to be done. Then, the right to have their trial begin and conclude without unreasonable delay. Now, what is reasonable in South Africa might not be reasonable in other countries. Trials in our countries do take a long time to start and even conclude. So what is reasonable in the context in South Africa? But I have the right for my trial, at least when it starts, to conclude within a reasonable time. Then I have the right to be present as the accused when being tried. Essentially, a trial cannot continue without the accused being present. There are certain exceptions in this regard, but generally the accused person must be there. Then, again, legal practitioner. Either the right to choose a legal practitioner or to have one assigned by the state and at state expense if substantial injustice would otherwise result. Then, very, very importantly, the right to be presumed innocent. The right of presumption of innocence implies that it's not up to me to prove my innocence, it's up to the state to prove my guilt. Right, so the onus rests on the state to prove my guilt. And this has an important implication not only for the standard of proof and the burden of proof, the onus of proof on the state, it has an important bearing also on how I should be treated in terms of the criminal justice processes. Always a person should be treated from the perspective that this person is innocent until they have been proven guilty. Then also you see there the right to remain silent and not to testify during proceedings. Remember, this includes also the contrary, the right not to remain silent and the right to testify during proceedings. Then the right to adduce and challenge evidence. Now, these are not the only Section 35(3) rights. We'll move on to a few others on the next slide. To adduce and challenge evidence is an important part of the confrontation principle. And when I say confrontation principle, I'm essentially talking about the old natural principle of justice, which is audi alteram partem. Hear both sides of the case. So only after a court has listened to both sides of the case should it be in a position to make a decision, a reasoned decision, and decide whether the person is guilty or not guilty. Continuing with the fair trial rights of the accused person in terms of Section 35(3), the accused person also has the right not to be compelled to give self-incriminating evidence. In other words, to testify and during testimony answer something that could be used as evidence against them. So this clearly links very closely with the right to remain silent, but even if the person decides not to remain silent and testify in his or her own defense, they cannot be forced to answer a question, the answer of which can be used as evidence against them. Then, the person has a right to be tried in a language that he or she understands, and if that's not practicable, to have the proceedings interpreted in a language that they are comfortable with. Now, this is a result of the different official languages in South Africa, and it gives effect to the right in Section 35(4) of the Constitution. So the idea here is Any proceedings, any questions, comments that are made during the course of the trial must be reinterpreted into a language that the accused person understands so that he or she can participate in the proceedings meaningfully. Then, an accused person has the right not to be convicted for an act or an omission that was not an offence under either national or international law at the time that it was committed. Now, this constitutionally guarantees the principle of legality. And so, briefly, the principle of legality is about the fact that if I do a certain thing, I commit a certain action or omission, but at the moment when I do that specific action, it is not regulated by law as being unlawful, as being a crime, I cannot be punished for that later. So generally the law does not work retroactively. If I do something at the time when I do it, the law must consider it by way of criminal law as being a criminal offence. If not, if I commit it and only days, weeks, or months later it is now being turned into a criminal offence, I cannot be held criminally liable for that action as a criminal offence. The law is not retroactive. Then, I have the right not to be tried for an offence in respect of an act or omission for which the person previously was either acquitted or convicted. You may have heard the phrase double jeopardy. So if the person on a previous occasion on the same set of facts has already been tried and has already either been found guilty or not guilty, they cannot be retried again. Then, the benefit of the least severe prescribed punishment. Now, in this regard, it's important to note that many of the common law crimes in South Africa do not have an attached minimum prescribed sentence or punishment. The court generally has a discretion, and the court can make a decision guided by previous sentencing precedents. However, there are certain types of crimes in South Africa where, in terms of legislation, there are prescribed punishments. So in terms of the Criminal Law Amendment Act, there is prescribed punishment for something like premeditated murder or for rape. Under those circumstances, if the prescribed punishment in legislation changed from the time that I committed that offence to the time that I'm now found guilty of the offence, I'm entitled to receive the less severe prescribed punishment between those two available options. Finally, I have the right as an accused person to appeal and or review to a higher court. Depending on the circumstances, there are different reasons why an accused may want to appeal or may want to review. And generally, an accused person doesn't really take an active role during the review of proceedings, but either way, this appeal or review will be referred to a higher court, and an accused person has a right, after having been found guilty and imprisonment, or a sentence having been imposed, the person will have the right to appeal or review that decision.
In extending the due process rights of an alleged perpetrator, we also need to look at Section 35, subsection 4 and 5. Now, Section 4 effectively says that whenever a person should be told about their rights in Section 35, subsection 1 to subsection 3, whether that is during the pre-trial by a police official or during the trial by a judicial officer, that this information must be promptly and clearly explained to the arrested, detained, or accused person in a language that that person understands. Now, this is very important in South Africa, where we have multiple languages. Second important protection there is Section 35(5), which is the exclusionary rule. Now, we'll unpack the exclusionary rule in a little bit more detail later, but effectively, what the exclusionary rule says is that during the investigation of a crime, as evidence is obtained, if that evidence is obtained in a manner that violates any right in the Bill of Rights, to the extent the admission of that evidence would either render the trial unfair or would be detrimental to the administration of justice, then it is possible that the court may exclude that evidence as admissible evidence at trial. So providing for evidentiary protection, evidentiary remedy against the obtaining of evidence by police officials in a severely unconstitutional way. Let's test our knowledge with some application of law to facts. X was arrested on Friday morning, 1 September, 9:15 in Randburg. During the arrest, the police informed him that he was being detained as a suspect in the murder of Y. Now, in relation to the set of facts, consider the following questions. Now, I'm going to work through these questions one by one and give you the answer. But what I would suggest you do, before I give the answer to the question, perhaps pause the video for a moment and see if you can answer the question before you listen to the response that I give. So I will give you a second or two so that you can pause the video after I've read the question and before I give the answer. Here we go. Question 1. Identify the relevant legal descriptor or descriptors or designations applicable to X on 1 September and specify the corresponding set of due process rights. You must also provide examples of 3 due process rights to which X is entitled from this identified set. Right, so hopefully you had identified correctly that at this stage X is the arrested person. In other words, the corresponding set of due process rights that is applicable to him at this stage is section 35 subsection 1. Did you, however, also identify that by definition, the moment a person is arrested, they are also a detained person? So from that point of view, there are 2 legal descriptors applicable to X on 1 September, that of the arrested and detained. In other words, X is entitled to all of the rights in section 35 subsection 1 and subsection 2. And these include things like the right to remain silent, the right to legal representation, to basic conditions of detention, and so forth. You are welcome to go back to the rights that we discussed earlier. Now, second question. At what stage of criminal procedure is this case currently? We are currently busy, obviously, with the pre-trial investigation stage, or simply the pre-trial stage. From the set of facts, X is only being considered as a suspect. In other words, X has not been charged for a criminal offense as yet. He is merely a suspect, and police would like to do further investigation, and he might be brought before an investigating officer for something like interrogation. They might take fingerprints and DNA samples from him, and so forth. So at this stage, we are not at the point where a decision has been made, whether formally or informally, that X is going to be prosecuted for this offense. So we are still only at the pre-trial stage. Which branch defines the crime of murder? Well, I think this more relates to information that we did last year. The key for me here is that you need to realize the name of this course implies that criminal justice is not only criminal law, criminal procedure, or law of evidence. These are not silos. These fields, these branches of law act together in the interest of criminal justice. So you might be asked questions that you might have done in a previous course, but directly relates to the information that we are doing now. However, I won't do that easily, and I will warn you if I intend to do that in an assessment. Answering this question, what branch of law? Well, obviously that would be substantive criminal law, or just criminal law. I might also then ask you to define the crime of murder together with asking you which branch. And by now I'm sure you know that murder is the unlawful and intentional causing of death of another human being. Fourth question. Within what time frame must X be brought before court for his first appearance following his arrest? You might be on the right track, but let me give you the formally correct answer. The formally correct answer is, if we ask within what time frame, the correct answer is as soon as reasonably possible. That is your standard answer. Soon as reasonably possible, but not longer than 48 hours. Now, because this relates to a specific set of facts, the idea is that you also identify the date and perhaps the time by which X must appear before court. Now, in this set of facts, the 48 hours within which X must be brought before court runs out over the course of the weekend. So that means, in terms of the principles that we've discussed, X must be brought before court no later than the first ordinary court day after this weekend. Now, let's say, for example, that Monday is a public holiday, then the next ordinary court day will only be on Tuesday. But let's say it's not a long weekend. That means that X will have to be brought before court during the first ordinary court day, which would be the Monday, and the end of court would the ordinary court day would be 4 o'clock. So your answer would be as soon as reasonably possible, but within 48 hours. And in relation to the specific set of facts, it will be on Monday before the close of court hours at 4 o'clock. Then the next question, which court has jurisdiction to hear X's bail application? Short answer would be the magistrate's court. I don't need you to distinguish between whether it will be the regional or the district magistrate's court. If you simply identify it's the magistrate's court, I am happy with that answer. However, if I do ask the question regarding jurisdiction, but not specifically bail, so let's say I ask you which court will have jurisdiction to hear this case, murder case, then you need to identify it is the regional magistrate's court, or potentially it is the high court. You need to be more specific. But when it comes to bail, if you tell me the magistrate's court, I will be happy with that answer. Next important topic is excluding unconstitutionally obtained evidence. Now, this is a topic that will be discussed in both the context of criminal procedure and later in the context of the law of evidence when you do that specific module. Now, the exclusion of unconstitutionally obtained evidence is regulated by Section 35(5) of the Constitution, also referred to as the exclusionary rule. And the idea here is to provide a constitutional evidentiary or a procedural remedy for an infringement of rights. And the infringement of rights that we are talking about here is a severe infringement of rights that came about as a result of the obtaining of evidence. So what this exclusionary rule basically says is, if in the process of obtaining evidence, police officials severely infringe on constitutional rights, then that evidence may potentially be excluded as admissible evidence in court. Now, Section 35(5) is effectively grounded in three interrelated values that are central to a due process model of criminal justice. First is the judicial integrity model, where courts must protect the integrity of not only the judicial system, but also the criminal justice system as a whole. And for that reason, should be very careful in condoning such police misconduct in obtaining evidence. The second important principle is the deterrence principle, where courts aim to discourage future police misconduct in the obtaining of evidence. And then in the third principle, the corrective principle, aims at redress. So in effect, the criminal justice system must have a built-in ability to self-correct any internal abuse. And that is, from this perspective, Section 35(5) provides for a redress as a result of the obtaining of evidence in a severely unconstitutional way. As a starting point for this discussion, I want to point to the case of Key in 1996, a Constitutional Court decision, in which the court held that what the Constitution demands is that the accused be given a fair trial. At times, fairness might require that evidence unconstitutionally obtained be excluded, but There will also be times where fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted. Now, in effect, what the court is saying here is that Section 35(5) must be applied in a manner that strikes a reasonable balance between competing interests. Now, these competing interests are principally the due process interests of the accused to a fair trial, the interest of the victim in the punishment of a guilty accused, the interest of the state in ensuring that law enforcement agencies do not abuse their powers, the interest of the judiciary in ensuring the integrity of the criminal justice process and the administration of justice, and of course the general interests of society in safety and security, and often, as it relates to the interest of the victim, that there be accountability for those that have committed an offence. So in the process of gathering evidence, some infringement of a person's constitutional rights is inevitable. Every exercise, or let me rephrase, most exercises of authority with the intention to obtain evidence will have some kind of effect on the constitutional rights of a person. It is inevitable. If a person is searched for the purpose of obtaining potential evidence from that person, then that is an infringement of rights. So we cannot really move away from the fact that there will be infringements on constitutional rights as a result of the process of gathering evidence, the exercise of authority in order to gather evidence. So what we are saying is this will happen, and that by itself does not mean that evidence will be excluded. But the question is, under which circumstances will evidence unconstitutionally obtained during the investigation process be inadmissible in court? So here we need to talk about the test that we find, the two-pronged test that we find in Section 35(5). Let's look at the test for excluding evidence in terms of Section 35(5). Effectively, the presiding officer is given a discretion to determine whether the evidence, hypothetically, if it was admitted, would have one of two consequences. Either it would render the trial unfair, or it would be detrimental to the administration of justice. If the court finds that, hypothetically speaking, the admission of that evidence would have that effect, one or both of them, then the court must exclude such unconstitutionally obtained evidence. Now, let's just have a look at these two outcomes. What do we mean? First one, evidence must be obtained if the admission of that evidence would render the trial unfair. This is the interest of fairness inquiry. So basically asking whether the admission of that evidence would actually render the trial unfair. It requires weighing the protection of the accused's substantive and procedural rights at trial against the concerns of society that basically the truth is sought and the guilty is punished. The essential practical test requires balancing, on the one hand, the severity of the rights violation and the degree of prejudice to the accused, against, on the other hand, the public policy interests in convicting an accused. So the rights violation would be severe where police conduct in obtaining evidence would be considered deliberate or flagrant. A good example, police use torture to obtain a self-incriminating statement from an accused person, for example. That would clearly render the trial unfair. On the other hand, the rights violation might not be severe or not be considered severe where the police conduct is objectively reasonable. So, as I said earlier, usually in the process of obtaining evidence, when police officials exercise authority, it will have some effect on the constitutional rights of the affected person. But by itself, that does not necessarily mean that it is a severe infringement for purposes of rendering the trial unfair. Alternatively, evidence obtained in a manner that it violates any right in the Bill of Rights must be excluded if and only if the admission of that evidence would alternatively be detrimental to the administration of justice. Now, this is the interest of administration justice inquiry. The idea here is asking whether admitting the evidence would condone serious police misconduct, serious abuse of power, overzealous abuse of power, corruption, for example. And then would that undermine the judiciary's role in upholding the constitutional values and the rule of law if such evidence is allowed? So effectively, if this violation is so severe that allowing it would basically say to police officials, you can effectively do whatever you need to do to obtain evidence, then that will undermine the administration of justice. And the court here has a responsibility to ensure that the administration of justice is fair. So, therefore, must exclude such evidence. Now, the courts must ensure that state law enforcement agencies act in accordance with the Constitution in order to prevent the judicial process, this administration of justice, from falling into disrepute. Exercising the court's discretion when deciding whether or not the admission of evidence would render the trial unfair or would be detrimental to the administration of justice, the presiding officer must consider all relevant circumstances. Now, there's no concise list in this regard, but a good list of factors or circumstances that should be considered was outlined by the Supreme Court of Appeal, that is, in the Pillay case. So in that case, the court listed the following considerations. 1, the kind of evidence that was obtained. 2, the constitutional right or rights that was infringed as a result of obtaining that evidence. Was such infringement serious or merely of a technical nature? And would the evidence have been obtained in any event? Those would constitute some of the primary circumstances that a court must consider. Importantly, in Tandwa 2008 Supreme Court of Appeal case, the Supreme Court of Appeal clarified that unconstitutionally obtained evidence is not automatically excluded. In other words, such evidence is prima facie admissible until the court, in its discretion, determines that admitting it would either make the trial unfair or be detrimental to the administration of justice, as outlined in section 35.5. Now, the significance of this decision in Tandwa is that it effectively shifts the burden of proof onto the party challenging the evidence, which for our purposes would usually be the accused. And so the burden is now on that party to convince the court that admitting that evidence would be admitting the evidence that was unconstitutionally obtained would either render the trial unfair or be detrimental to the administration of justice, or both. Here is another application of law to facts to test your knowledge. I give you a set of facts and I ask you a few questions. Now, on this occasion, I'm not going to work through this application of law to facts with you. I would like you to do this by yourself. Criminal justice requires balancing the individual perpetrator's right to procedural fairness, due process, with society's interest in effective crime control and accountability for the harm committed. Now, to achieve this, there must be limitations on the exercise of state power. Remember, in this regard, law enforcement agencies of the state, in the interest of achieving certain crime control objectives, exercise certain powers like search, seizure, or arrest, and by doing that, inevitably infringe on human rights. So criminal procedure safeguards individual constitutional rights, including human rights and due process rights, by imposing reasonable checks and balances on the crime control powers and the extent of crime control powers by, for example, and most importantly, the police services, but also potentially the prosecuting authority, the NPA. I want to draw your attention to the fact that various terms, phrases are used in this context. In the context of criminal justice, terms such as crime control powers or crime fighting powers or investigatory powers are usually used to refer to the exercise of a specific branch of the government, specifically the South African Police Services, acting within its scope of power to serve certain crime control objective. So to search, to seize, and to arrest, these are investigatory powers or crime fighting powers or crime control powers. Law enforcement powers is another term that is often used interchangeably, but that together with something like state power could potentially be a little bit broader, because the law enforcement powers in South Africa also extend to the powers exercised by the National Prosecuting Authority. The same goes for state power. Usually in a criminal case, the case is referred to as S versus the accused, state versus. That state is effectively referring to the National Prosecuting Authority exercising its authority to prosecute a certain individual. So what is important that you understand in this context is that there are different terms, different phrases used. Sometimes they refer to the exact same thing with different terminology, but there are potential differences between some of these phrases. The idea here is that the state, the South African government, is exercising its vertical authority over its inhabitants, which usually has a knock-on effect on people's human rights, but they do so in the interest of justice and on behalf of society in alignment with the state's constitutional duty, which is to ensure public safety, to uphold the rule of law, to maintain social control, and to preserve societal stability and peace. First and foremost, it is important to realize that the exercise of crime control powers is essential to the protection of everyone's human dignity and all personal or public interests. We all have competing interests, and for that reason, there is this idea of law that keeps each of us in our specific scope or sphere so that we don't infringe on each other's rights. Now, part of exercising crime control powers is to make sure that everyone stays within these specific parameters of rights and freedoms so that we don't infringe on other people's rights. So crime control is necessary. However, we should also note that while crime control powers is necessary, and something like investigatory powers by police is necessary in order to obtain evidence, for example, rightly or wrongly, any person may be implicated in the commission of the offense. And the moment a person is implicated in the commission of an offense, they are brought into contact with these crime control powers of the state, these crime fighting powers or investigatory powers. And as an inevitable consequence, there will be an impact or an infringement on their rights. So generally, you cannot exercise state powers, investigatory powers, for example, without affecting people's human rights. So the two go hand in hand. Take that example. If police officials search my house, it effectively infringes my right to privacy and my right in regards to property. If the NPA decides to prosecute me, it may affect my freedom of movement because I will need to be in court during the process of the criminal proceedings. And that may affect also my right to practice my trade, occupational profession, because I won't be able to work during the time when I am in court. So what is clear is whenever state powers in regards to law enforcement or crime control is exercised, usually, inevitably, it has an impact on a person's human rights. That extends not only to the person implicated in the commission of the offense, in other words, the alleged perpetrator, but that extends to, for example, witnesses who must come to court to testify, for example. So it's not limited only to the alleged wrongdoer. By now, it should be clear that it is very much foreseeable that the moment law enforcement agencies exercise powers, law enforcement powers, it is inevitable that there is going to be a consequent effect on human rights, on constitutional rights. What should be added to that? It is acceptable that there is this detrimental effect. So we foresee that exercising law enforcement powers will have a detrimental effect on human rights, constitutional rights, and that effect is acceptable provided it is done within certain limits. And that opens the door for our discussion on the limitations on the exercise of state power. So, effectively, to limit this detrimental impact on society, whenever the state exercises powers through various branches of authority, and that power has the foreseeable impact on rights, such exercise of power must be reasonable and justifiable. How is this achieved? Well, this idea of exercising power within certain limits, certain acceptable parameters, is achieved through a number of practical tests, so to speak, checks and balances that we find in the Constitution, we find in common law, we find in legislation. So these practical tests, these checks and balances, ensure a proper, a proportional, a reasonable and justifiable exercise of power. So what this means is that legal reasoning, legal decision-making necessitates that the exercise of state power be evaluated against these acceptable parameters, these checks and balances. We need to weigh the two. We accept that there might be a detrimental impact on rights as a result of the exercise of power, but it must be done within acceptable parameters of state power. Once we accept that the exercise of law enforcement powers will inevitably impact constitutional rights, the next step is to understand the parameters set by the various checks and balances that regulate this power. Now, these acceptable parameters, these checks and balances, are set out in relevant enabling statutory provisions, such as those that we find in the CPA. So these enabling statutory provisions allow police officials to exercise certain powers, for example, so to search and seize, to enter premises, to hold an identity parade, to monitor and intercept private communications. All of these are enabling statutory provisions that allow police officials to exercise powers. We also find these checks and balances in the Constitution and even in the common law. Now, what these checks and balances do is they effectively define the parameters, the scope, and the context within which law enforcement powers may be exercised. So it basically says that a police official, for example, may exercise this or that power under these circumstances. But it goes a step further than that, in that it tells police officials that they may exercise these powers, but because these exercise of powers will have an inevitable effect on a person's constitutional rights, it must be exercised in a way where it makes as little as possible impact on the person's fundamental constitutional rights. Now, let's turn our attention to some of the most important of these checks and balances. If we understand that these checks and balances play a very important role in limiting the context within which powers are exercised and the extent of that power so that it doesn't unnecessarily infringe on rights, let's talk about some of these most important checks and balances that achieve this purpose in the context of criminal justice. Let's discuss the most important checks and balances that not only limits the scope of the exercise of power to certain contexts or to certain circumstances, but also the extent of that power so that we mitigate the consequent or the resulting effect on human rights. Now, the first one we won't discuss in detail because this is something that very much links to criminal law and has been discussed previously. The next and very important one is the reasonableness test. So the idea with the reasonableness test, which we find in various statutory enabling provisions is that crime control powers by police officials must be exercised reasonably, in other words, objectively, and within the confines of what the enabling statutory provision says. So the enabling statutory provision provides for the context or the circumstances within which certain powers may be exercised and the extent of that power. The question of reasonableness is, did the actions of a specific police official in exercising a certain investigatory power, did it stay within the reasonable limits of what that statutory enabling provision allows for? So, reasonableness test is something that is very important for purposes of this course, and it is something that we will discuss in more detail as we go along. The next important test is the interest of justice test. Now, interest of justice is a phrase that you will hear quite often in the context of criminal justice, and it is something that we've used quite often as well. From the perspective of a check or balance, the interest of justice test is used in particular circumstances, such as where the interest of justice in deciding whether or not bail should be granted to an arrested and detained person, or the interest of justice is an important part of the NPA's consideration when it needs to decide whether or not it is going to prosecute a person for a specific offence or not. Apart from the important common law and statutory checks and balances that we've discussed, it is also important to look at the checks and balances in the Constitution. The first very important one is the constitutional justifiability in Section 36. So Section 36 effectively says that any right in the Bill of Rights may be limited under certain circumstances. Now, what we are discussing here is whether the limitation of rights as a result of the exercise of police functions, police powers, are justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account the relevant factors outlined in Section 36(1). So what we are really asking is, if police officials exercised a certain power, let's say a search and seizure, and the exercise of that power was reasonable, the next question would be, was the rights infringement that resulted from the exercise of that power constitutionally justified? We may limit people's rights in the exercise of police powers, provided it is constitutionally justified, and that is where Section 36 plays a very important role. The last important check and balance that we are going to talk about is the exclusionary rule, which we've already discussed, Section 35(5) of the Constitution. And as mentioned, this serves a very important constitutional, evidentiary, or procedural remedy role by barring the use of severely impugned, unconstitutionally obtained evidence. So it is a check and balance that if evidence, for example, was obtained unconstitutionally, to the extent that it was resulted in a severe infringement of human rights that is not constitutionally justifiable, then to provide redress, that evidence may potentially be excluded at trial. When considered cumulatively, these practical safeguards, these checks and balances, put courts into a position where they can assess, based on Section 2 of the Constitution, the testing right in Section 172 of the Constitution, whether certain conduct fell within the legal parameters of what is lawfully considered the exercise of powers. So for our purposes particularly, this will relate to the exercise of crime fighting powers by police officials, which is something that we will discuss in more detail as we go along. But it could also relate to the exercise of the authority and the discretion by the prosecutorial authority, the NPA, when they need to decide whether or not to prosecute a person. Both these two sets of exercise of powers relate to law enforcement powers, and both will have a consequent effect on a person's fundamental rights. And for that reasons, various checks and balances will apply before and in the exercise of these powers. Let's test our knowledge and do an application of law to facts. So here's the given set of facts. Tuli is walking home from work when two police officers stop her regarding a recent burglary. Without a warrant or reasonable suspicion, they demand to search her phone and handbag. When Tuli hesitates, they forcibly take her phone, scroll through her messages, and access her call history. They also empty her handbag onto the sidewalk, exposing her personal belongings to bystanders. Now, in relation to this set of facts, there are various questions that I can potentially ask you pertaining to the preceding discussion. So, first question, did the search by police officials infringe Tuli's rights? Well, clearly, yes, but you need to be more specific and you need to identify which rights were affected. So, first and foremost, I would argue that Tuli's right to privacy, section 14, has been infringed. But what other rights potentially have been infringed? I would encourage you to go to the Constitution, Chapter 2, the Bill of Rights, and consider the rights listed there and which potential rights there have been infringed by this specific action by police officials. Now, moving on. Next question there is very broad. Was the exercise of state crime control powers in this case reasonable under the circumstances? Okay, now if we need to break down, or we do need to break down this question a little bit before we can answer it. First question would be, to answer this question, may police officials search someone's phone and handbag, scroll through their messages, etc.? Is there an enabling statutory provision that allows for this? Yes, there are provisions in the CPA that allows for the exercise of powers such as search and seizure. What exactly those are, we will discuss when we get to that part of the work. But for now, we can assume that the state may exercise certain powers such as search. The question, however, in this situation is, and when we link this to the preceding discussion regarding the checks and balances, was the exercise of that crime control power in relation to the enabling statutory provision in the CPA reasonable under the circumstances? In other words, was the power exercised, objectively speaking, in a way that falls within acceptable parameters under the circumstances? Broadly speaking, I'm sure you would agree with me here that there is no way that this was reasonable under the circumstances. There were various other ways in which police officials could have done this, provided they actually either had a warrant or had some kind of reasonable suspicion. We cannot allow police officials to go around in public searching whomever they feel and want without having a basis for the infringement of rights that occur. And that is where the reasonableness question comes to the fore. That brings us to the end of this learning unit. But it is very important that you note that the content of constitutional criminal procedure directly links to the exercise of investigatory powers for purposes of this course. So you need to study this learning unit together with the exercise of investigatory powers and investigative arrest, as we will discuss in future learning units.